I'm Paul Grimm. I am a retired U.S. District Judge, and I'm on the faculty here, and I'm also the director of the Bolts Judicial Institute. And the Bolts Judicial Institute is absolutely as happy as we can be to partner with the American Bar Association litigation section, particularly with the Committee on the American Judicial System and the Berkeley Judicial Institute, to bring you what is the third of a series of discussions that will continue into 2025 and perhaps thereafter that talk about the impact of the United States Supreme Court on ordinary folks. And what we are trying to do is we're trying to engage not only with you who are infected by being in the law, but also folks who are not. And what we'll be doing is this will be live streamed so that there are people all over the country who may be listening in. Afterwards, it's also being recorded. It'll be posted on our website, possibly the Berkeley website and the ABA as well, so that you can have access to it. And what each of these particular presentations focuses on is some aspect of how the Supreme Court affects our lives. Today, we're very current because the title of our presentation today is How the Supreme Court is Reshaping Our Everyday Lives, Air, Water, Medicine, Food, Fishing, Credit Cards, and much more, with emphasis on much. And the basis for this is the 2023-2024 Supreme Court term. And in our complex society, federal agencies regulate virtually every important element of American life. There's so many administrative agencies that some people say you can't even come up with a correct number. There's a debate about how many numbers that we have. They deal with the quality and the safety of our air, water, and food, the safety and availability of medications and consumer products. And in this last term, the Supreme Court had 4 significant decisions that changed how those agencies can operate. They may no longer be able to regulate matters of great economic and political significance without explicit congressional authority to do so and direction. No longer are courts required to defer to agencies' expertise when interpreting ambiguities in statutes and regulations that affect the work of those agencies. Regulated parties for whom the agency may seek civil penalties, because there are far more administrative hearings that try cases than actual judicial hearings, may now be entitled to a jury trial. And people and companies who want to challenge regulatory action may now have a significantly longer period of time in which to do so. These historic Supreme Court decisions that relate to the authority of agencies, they have the potential to radically change how businesses and institutions operate and how Americans live their day-to-day lives. This panel will explore the ramifications and far-reaching impacts of these Supreme Court decisions and the perspectives of the law, the courts, and the regulated industries. So I'd like to welcome our panelists in from the far left to the right. That is a geographic designation, not a political designation. We have Jennifer Zachary, who is General Counsel for Merck, the pharmaceutical company. We have with us Chief Judge Catherine Eagles of the United States District Court for the Middle District of North Carolina. Then we have Senior Attorney David Doniger for the Natural Resources Defense Council, and our moderator, our own Professor Stuart Benjamin here at Duke Law School. I would like to personally thank Beth Kaufman, co-chair for the Committee on the American Judicial System of the ABA Litigation Section. Thank you so much for being here and for being one of the founders of this, the inspirations for this to occur. And of course, Lawrence Pilgrim, also from the American Bar Association Litigation Section. And with that, I just want to shout out to our co-sponsors, not only the ABA Litigation Section, but the Berkeley Judicial Institute as well. So, I said that, but I will say it again. We are live streaming and recording. So when we get to the Q&A, just be aware that you are speaking for the ages. Thank you all very much. and I look forward to this conversation.
Thanks, Paul. So I thought I would I'd ask you just to begin, just to set the table a little bit and talk about the cases that Paul was referring to. So the Supreme Court would not want me to characterize it this way, but just for your benefit, from a standpoint of an agency lawyer, these are a set of cases that make it somewhat more difficult for the agencies to do what they might want to do. Now, you can have your own normative judgments about whether or not that's a good idea or a bad idea, but I think it is fair to say that that agencies would have basically in all of the cases that I've talked about have preferred they come out the other way. The second thing that I know we'll talk about in the panel is, and some of these cases create some uncertainty. So let's first mention the most prominent of these cases that you may have heard of, the Loper-Bright case. So the Supreme Court, in a case that David argued, the Chevron case, had said that if the statute was clear, then that was the end of the matter. And if the statute was not clear, then the court would defer to any reasonable agency interpretation. And in Loper-Bright, the court overruled that Chevron decision. It would be hard to overstate how many times the Chevron was invoked over the years, although it had not been invoked for a while in the Supreme Court. So this is actually one of those situations in which getting rid of Chevron, we can discuss, might have had less of an impact on the Supreme Court because it was already pulling back. But the key thing for our purposes, to cut to the chase, because I want to get to these cases and then get to questions, is that in Loper-Bright, the court said, no, we are going to engage in the statutory interpretation, and we are not going to defer to the agency interpretation. Agency interpretation may be entitled or is entitled to some respect under a case called Skidmore, but giving some respect to an interpretation is different from deferring to the interpretation. We are still ultimately making the decision. Now, there's lots of debate about how much of a difference that actually makes. I'm just trying right now just to get the top level case out, and then we can the top level line out, and then we can go on to the other cases. On the discussion. Second case that I want to mention is one that you may not have heard of. Is a case called Ohio versus EPA. The reason you might not have heard of it is it came in a strange posture. It was sort of in a somewhat preliminary posture, and it's a case that really goes into the weeds of how an agency justifies its decision. But I think it's fair to say that the Supreme Court majority was reasonably either aggressive or more careful than usual in looking at the agency's justifications for its decisions as a policy matter, and whether or not it had justified the policy decisions that it had and the factual decisions that it had made, over a pretty strong dissent by the more liberal justices and Amy Coney Barrett writing for the four dissenters, saying, look, the arguments that you are saying that the agency should have taken into account, in effect, they did take into account, and you're really fly-specking this case. So that's the second of the two cases, Ohio versus EPA. It's probably the least well-known, and I'll just tell you right now, we have the hardest time of knowing what its impact is going to be. It's just one case, fact-specific, et cetera, et cetera. A third case that I wanted to highlight is a case called Corner Post. And Corner Post involved a statute that said you had to sue within 6 years after the right first accrues. And the court said, well, the right doesn't accrue until you've been injured. And so even if the regulation was issued 50 years ago, if your organization was just founded a year ago, then you get to challenge it. Now, in some ways, that sounds huge, because guess what? Any of you can create a new corporation tomorrow, or create a new trade association tomorrow. There is no limit on the imagination of somebody to create a new entity. So in some ways, that sounds massive. Let me tell you the way in which it's maybe not so massive is there are actually only 12 statutes that use the first accrues language. However, one of them is the Federal Tort Claims Act, which is a big deal. There actually are lots of statutes that specifically provide, for instance, that there is a 60-day limitation after the rule is issued. So there's none of this first accrued language. You got to file a suit within 60 days. So for those statutes, those cases that are under the first accrues language, it is a big deal, but that is a subset of agency decisions. And the final case that I wanted to mention, because I know it's one that's of interest to Jennifer, is actually, I lied. The final case from this past term I wanted to mention is a case called SEC versus Jarkisy. And that, as written, is a fairly narrow case. It has to do with a fairly unusual provision for the agency itself to have an adjudication. And the holding was that when you're seeking civil penalties for anti-fraud violation, agency don't get to do that. That looks too much like a common law fraud case. You have to bring that into court. So that holding is reasonably narrow. The question is, will they expand it and make it harder for agencies to engage in adjudication and send everything to courts? So those are all cases from this past term. All of them are significant, and again, significant in ways that agencies might not be wild about. In addition to those, something that Paul referred to is cases that were not from the last term, but from the two previous terms, involving what has come to be known as the major questions doctrine, in which the Supreme Court has said that in extraordinary cases, Congress has to clearly give the agency authority. And extraordinary cases are defined as those that have enormous economic and political significance, and the court also says beyond what the agency has done in the past. That's also quite a big deal, because it means on really important matters, we're going to look for pretty clear language that Congress has provided. That is, we're not going to do ordinary statutory interpretation. Justice Barrett said we should be doing that. Was a concurrence. The majority said, in effect, no, we're not just going to do straight statutory interpretation where we just try to figure out exactly what the statute means. We're going to look for some real clarity from Congress. And so that means in whatever is going to be called a major question, if there is not this clear language, the agency can't regulate. This isn't about deference. This is the agency cannot regulate. All right, that's as much as the introduction as I want, because I want to get to the discussion. So let me jump into it and talk about the fact that one of the things these cases involve is a fair amount of uncertainty. So it's not clear exactly how Loper-Bright will be applied. It's not clear how broad SEC versus Jarkisy is going to be. It's not clear that Ohio versus EPA portends anything. It's not clear what is going to be a major question going forward. And so I'll throw this open to the panel, and I'll tell you, I emailed them in advance and said, here are the questions, and I'm going to throw it open, and you all can go speak in whatever order makes your heart sing about how you think about the upside and the downside of that uncertainty. So whoever wants to start should just start talking or raise their hand or otherwise indicate.
Everybody always looks at me first.
Yeah.
You're the chief judge.
Yeah, so what happens anytime the Supreme Court changes the law is I get told it changes the law a lot. And when you look at Loper-Bright, there's like 20 cases in the Fourth Circuit from either district or the circuit court addressing Loper-Bright, and half of them say, well, yeah, but Loper-Bright doesn't even apply here. And so this is what happens to us at the trial level when the Supreme Court changes the law, is we are told often, oh, this case changes everything. And at least half the time, it does not. Now, there are some cases that did. If you go back 20 years to the Booker case and the sentencing guidelines, oh, good, I got some nods. All right, the people who are interested in criminal law, that really did change everything, and we knew it from the get-go. But some of these cases, we're going to be told it changes a lot of things, but whether it actually does is a totally different matter. And, district judges roll with the punches. Those appellate courts are always changing things on us. Congress enacts statutes that give us new authority. We all of a sudden get 500 compassionate release motions for sentence reductions during a global pandemic that nobody gave us any extra staff for. Hello. So we're used to rolling with the punches, and we will be taking them as they come.
And actually, I should have, let me ask a slightly more pointed question to Jennifer in particular. So, how about this? The people I know who are in Fortune 500 companies, by and large, do not like uncertainty. Yes. Now, by the way, sometimes it can be an opportunity, it can be an arbitrage opportunity. I got a clever thing. That's more for like Jane Street and the traders on Wall Street. But for companies, uncertainty is not their friend. I'm just wondering how you think about this.
Yeah, so it's interesting. First, I'll offer the caveat that while I am the general counsel of Merck, I'm not speaking on behalf of Merck. Not fair to quote me in briefs. And I'm probably also influenced by the fact that I started my career as an FDA attorney arguing for the agencies and did the same at DOJ. But I think you're absolutely right that business abhors uncertainty, right? It's just, we can adjust to all kinds of bad laws, even unfair laws, if we know what they are and we understand and we can plan for them. I think what's really challenging about this suite of Supreme Court opinions is that it's not clear what the law is going to be 6 months from now, a year from now. It used to be, we're engaged in the lobbying process. We help to shape the policy. We know the law that's coming. Congress gives us a period of time in which to implement, right? So we have this lead up. Now, if all of a sudden any district court judge, no offense, can suddenly interpret in a way that isn't consistent with the understanding of the expert scientific regulators or the people who participated in that process of shaping the legislation, that is deeply unsettling to us. The idea that all of a sudden long settled statutes can be with corner post. Now someone who's new to the game, a brand new biotech, can go in and challenge something that's been on the books for FDA for 100 years is really challenging. And so I think for us, what we worry about is that uncertainty. I think it's going to be really challenging to navigate. For a drug, for instance, between discovery and eventual marketing, we're looking at a 10 to 15-year period horizon, where if things change, that can profoundly disrupt our pipeline. And just to give you an example of like something concrete, the Food and Drug Act says that a drug can be approved if it's safe and effective. Well, what does that mean? Well, over the course of time, through a lot of agency determinations, we've come out with this idea that a drug is safe and effective if there are 2 adequate and well-controlled clinical studies. Well, what is adequate and well-controlled? Well, there's a lot of agency guidance that describes that, but it's not 1 study, it's not 3, it's 2. Now, if suddenly people can challenge that, we've been working on a drug for 12 years and our whole development program could blow up. So the uncertainty has dramatic impacts. We'd rather just know what the rule is.
By the way, but the drug trials only cost like $1 billion.
Yeah, it's no big deal. It's no big deal. Yeah.
Well, first I want to emphasize my bipartisanship. I drink both kinds of diet. Soda.
Officially noted.
And I have the maybe unique position of having been involved with Chevron. I argued the case in 1983 and 84, and we filed an amicus brief in the Loper-Bright case. And so I like to say that it's bookended my career, the birth and death of Chevron, and I've been on the losing side both times. We brought Chevron, in the case we brought under Chevron, it was interpreting a provision of the Clean Air Act that we thought was absolutely clear. And we failed to convince the Supreme Court that it was absolutely clear. And the Supreme Court actually ended up rebuking lower court judges for a series of related cases, including that one, in which the Supreme Court felt that the judges were inserting their own policy preferences to resolve ambiguities. I didn't think there was an ambiguity, they did. But then they said to the lower court judges, stop inserting your own policy preferences. The political branches, Congress, which made the big decisions and delegated some of the medium-sized decisions to the agencies, which are responsible to the other political entity, the president. They are the ones who should make these policy decisions within certain bounds. Initially, first of all, that was in a deregulatory case. That was in a case to basically destroy a program that Congress had adopted 5 years before by changing a definition. But it was, on its face, a neutral principle. It could be used to do less with laws or more with laws. And initially, it got a lot of pickup from judges and scholars, mostly on the conservative side, like Scalia and Starr and Silberman and others, saying this is the way it should be. They got much less, I give Scalia credit for consistency, but many of the others got less consistent with this when first Clinton and then Obama were in charge and began to use the discretion under Chevron to do more with the environmental laws rather than less. And I think this has occurred across many subject matters and agencies as well. The Federalist Society had been looking for a long time for a case to overturn this principle. And there's actually a tape of White House counsel McGahn back in 2017 or so, saying that the reason they picked Gorsuch to be on the Supreme Court is that he had written an opinion calling into question Chevron. Am I not loud enough? Okay. Is that better if I lean forward? They went fishing, so to speak, for a client, and they came up with these herring fishing boats in the Northeast. One of them is called Relentless. That's the companion case, and that would have been the better name for the Supreme Court decision. And there's a lot of pounding on the table in that decision that the legal questions are for judges, not agencies. It's based on a reading of the Administrative Procedure Act, which is not universal, but it avoids a constitutional set of reasons. And it contains in it a fairly interesting passage which says, look, when Congress writes a law, like the Clean Air Act or the Clean Water Act, and those are the examples given, which give discretion to an agency to make a determination, that is the law. So when judges confront such a law, their job is to define the outer boundaries of the discretion that the agency was given, and then to determine whether the action is, if it's in those bounds, whether it's arbitrary and capricious, which is a more deferential test that still stands. I won't go through the parallel language in Chevron, but that sounds a lot like Chevron Step 2. It doesn't sound that different. And Adrian Vermeule at Harvard has said, we're dealing with Loper-Bright delegation instead of Chevron deference, but it's not all that different. So it's not clear how much difference, other than the general signal of hostility to administrative agencies and the general signal to lower court judges that, you know, it's okay, maybe, if you insert your own policy preferences again.
At least until some other court inserts their policy preference.
Yeah. So it does introduce potentially a lot of instability. Probably less so for the Clean Air Act than many other areas, because the Clean Air Act has a very interesting feature, not very common. Most agency rules go to the DC Circuit. They don't go to district courts, and they don't go to the other circuits. There is a there's a venue issue that'll be decided next year, this coming year. But most will still go to the DC Circuit, and the DC Circuit is the most practiced with dealing with administrative law issues. And I don't think that much is going to change. That the makeup of that court has not changed much ideologically. So I'm cautiously hopeful that that Loper-Bright actually won't make the sea change difference that the Federalist Society types were looking for. That's probably a lot for me to have said in one opening salvo here.
Yeah, I mean, I do think we're going to see some shift to talking about delegation
Yeah.
instead of deference. You know, that's going to be the word
Right.
rather than deference. And, but, you know, that you were just talking about the language, that the court fulfills its role by recognizing constitutional delegations, fixing the boundaries of the delegated authority, and then in connection with the other case you mentioned, ensuring the agency has engaged in reasoned decision-making within those boundaries. Is that the same as arbitrary and capricious? I don't know. Fortunately, I am not on the DC Circuit.
Actually, I think they did say it is the same.
It
It's
is the
arbitrary-
same? Yeah, well,
If I
they
can,
start putting in
yeah, new words.
new words, and why are you using new words instead of the old words? Because they slide on us.
Can I just say one quick thing about the Ohio case? Sure. The Ohio case, I think the court was embarrassed that it ended up taking. It came up on the emergency docket. It involves implementation of a part of the Clean Air Act where upwind states have to be held responsible for curbing the pollution that goes to downwind states where the political incentives are not there to do it. You need a national authority to tell the upwind states that they got to take care of their neighbors. It's called the good neighbor rule. In the end, the decision, I think they ran out of all possible ways to strike it down, and they came up with the flimsiest thing that they could, which is that there's a supposed fault in the record. One argument that the EPA hadn't given a reason to answer to. Actually, they had. And they have since gone back and done the technical thing, the analysis that the court said hadn't been done. So if we weren't about to have a complete turnabout and change of administrations, where they probably will withdraw the whole thing and tell the upwind states it's okay to be bad neighbors again, if there had been continuity, the EPA would have been able to solve the problem the Supreme Court found, and that rule could have gone forward.
Yes, and by the way, in part of the frustration for the EPA was their concise statement of basis and purpose, concise is kind of a joke among administrators. It was 1,100 pages. All right, so and again, they know this in that. So two related questions. One is, which of these cases do you think has the most impact on the system as a whole, agencies, judges, courts, corporations, et cetera? And then the other is, which do you think is the most important for your particular part of the world? Merck, district judge, NRDC. But I first just want to ask the global question before I get into your particular part of the world. When you just look at, and again, this is for anybody, when you just look at these cases and you think about systemic impacts, which are the ones that you think, wow, this really might have a big systemic impact?
So I think if Loper-Bright ends up being sort of the broad version of Loper-Bright, whereby we disregard the technical competence and expertise of agencies, I think then across the whole economy, that becomes a very big deal. So that one for me would be the one.
Yeah, you know, I'm not on the DC Circuit. I think their world is really going to change with Loper-Bright. They are going to get so many challenges. And for us, none of these cases are going to affect our day-to-day world. We've seen employment cases, sentencing cases that are much more impactful on our day-to-day world. We are going to get a lot of arguments about them. We see the major questions argument, to just use a broad term, in any hot button case, there is the major questions doctrine. And we do get, all district judges see a lot of hot button cases these days. And that comes up all the time. And it's, I don't know what its scope is. Maybe is it the Supreme Court doesn't like this law, so it's a major question? I mean, I don't think that's actually going to end up being the rule, but we don't know exactly how they're going to apply it, because even though they said it wasn't new, it sure seems new. And we don't know. So I think we're going to see Loper-Bright a lot. It comes up in sentencing guideline questions. It comes up in Title VII questions. Exactly how that plays out, I don't know, but we're going to see it a lot.
I think that Loper-Bright will have a lot more impact in areas unlike the Clean Air Act, where the action goes to district courts or to other circuits. The Fifth Circuit is so hostile to the government that they're even being corrected 3-4 times a year by the Supreme Court majority. And, you know, this raises the issue of sort of the partisans, the judiciary becoming partisan, because you have cohorts of judges appointed by Trump. I mean, there's always some valence in the appointees with whoever the president is, but it's quite extreme compared to the prior norms with respect to the first Trump administration. And people might think that Biden corrected in the opposite direction, and now Trump is going to have an opportunity to appoint more. But it leads to a lot of forum shopping. And I don't have to do it because most of my stuff is automatically in the DC circuit. But FDA stuff, most other regulatory regimes, you can go anywhere your headquarters or your operations are, and they tend to want to go to the Fifth Circuit. So that's going to be important. And on major questions, that initially was developed as an exception from Chevron deference. Do we need it anymore if there's no Chevron deference? That's first question. And again, for a lot of law professors and, you know, practitioners in other areas look at Chevron, Loper Bright, and West Virginia from the general perspective.
West Virginia is a major questions case.
Major question case. I look at it from, these are all Clean Air Act rulings or adjacent to that. And I ask myself, how does this change the Clean Air Act regime? In the West Virginia case, the Supreme Court struck down a pretty expansive Clean Air Act rule on carbon pollution. But at the same time, the court said, this is what you can't do. They said, this is what you can do. This is the traditional way you've regulated in this area. So it affirmed implicitly a line of cases now, four Supreme Court cases long, that carbon dioxide and the other greenhouse gases are subject to the Clean Air Act. And it's just getting down to quarreling with how EPA regulates them. So there is a pathway still to act under that statute, but you have to have an administration that wants to do it. I mean, and we won't.
So now putting on, I should say that I'm both a moderator and supposed to be somewhat of a panelist. So let me now be somewhat of a panelist and answer my own question. I think that major questions may well be more significant than Loper Bright. I think those would be the two nominees for the ones that are going to be the most significant. But there is, there is a fair amount of uncertainty as to what we're even calling major questions. After Loper Bright, courts are still supposed to do ordinary statutory interpretation, and they're supposed to accord respect to the agency's interpretation. And that is, again, under this case called Skidmore. Let me just tell you, agencies win all the time under Skidmore. So Skidmore has been around for 80 years, like literally 80 years, and agencies win all the time. The uncertainty for major questions is, what are we calling a major question? Guess what? Every litigant says, what I'm suing about is really incredibly important. That's why I'm suing. And so now there's also, and the court has said, it also has to be something that the agency, it's beyond what the agency has done in the past. But still you can say, yeah, and I think what they're doing is beyond what the agency has done in the past. And let me just throw something else out, which is not from one of these cases, but it is something that is eventually going to reach the Supreme Court, is the question of nationwide injunctions. So if you're in a world in which you now have the ability to bring a lawsuit in any district, because you'll be able to find somebody in that district who can, and that district judge can issue a nationwide injunction, boy, does that make a single district judge's determination that this is a major question and therefore Congress has no power to regulate, and therefore this agency, this rulemaking that applies to the whole country, I'm now enjoining it as to the whole country. That's a really big deal. And so the interaction of the possibility of nationwide injunction and both major questions and Loper Bright is of, I think is of particular significance.
Well, and that ties in with the whole rule of law question you were talking about, because there are a number of places in the Fifth Circuit, but elsewhere, where you have one judge divisions. And so the judge shopping is easy. And Congress has expressed some concern about this, but I can't remember who in Congress it was that's gotten very concerned, and I don't know if they're still there or will have any power about it. But they, now that things have shifted or are about to shift, and it might be judges not letting the new administration do what they want to do, you wonder if they'll impose some restrictions on the nationwide injunctions, because that's been a huge topic among judges and in the literature for a while.
All right, so now I want to ask this question about your rule specifically, not about the whole system, but again, for you, just how, and David, you already answered that to some degree, feel free to say more, but for the NRC, for district judge, for Merck, which of these cases is, which of these cases is the most, significant? Which are the ones that are out there looming that you're, just don't know what to do with, et cetera? And again, people just talk in any order.
I'll jump in on this one and say I think that the most significant for my industry, but probably a lot of big business, is jarcossy. So this idea that a lot of what the administrative state does is done through admin law judges who are employees of those agencies and sit and ultimately report up to the top. And so just an example from the Health and Human Services world, if you go and look in the Federal Register each year, they have to print their civil money penalties. So these are the fines that they can get in their administrative courts. They have to print what they are and their authority. It stretches on for 22 pages. Almost everything that HHS regulates, which is more than 25 cents of every consumer dollar, has a civil money penalty associated with it. Currently, that goes through the admin law court and you get a fine at the end of the day. For instance, if someone underage walks into a vape shop and they try to buy a vape, and they sell it, the fine comes as an administrative penalty. Now, if jarcossy is expanded in the way that I think is the only fair reading of it, that's got to go to a district court judge. So now we're talking about, tens of thousands, hundreds of thousands of cases that are now going to flow through the courts. Personally, I think there's a lot of efficient ways to deal with those. But I do think it's a fundamental fairness question of, you could end up with hundreds of millions of dollars of fines being assigned by agencies where, a company or an individual had no right to be heard by a jury. So I think that case is going to be huge.
And what is the efficient way of dealing with these
So you can batch them, and then, because most people are going to what's your defense to I sold the vape? So a lot of these will end up getting settled. I think there'll be batch processing of them in the district courts.
And then Judge Eagles has to approve all of those.
Yeah, it's going to take a little while.
Yeah, I will say this has gotten very little attention from the trial, the district court bench. I guess maybe we're just avoiding the whole possibility of it. Magistrate judges have jurisdiction to deal with a lot of things. If you go over to the VA and you park where you shouldn't in the hospital parking lot, or you get into an altercation in the parking lot, or you get a speeding ticket on the Blue Ridge Parkway, these end up in front of United States magistrate judges, and they impose fines and penalties, but they're not very big.
Right.
I don't know. She's just giving me heartburn.
I'm sorry.
We are pretty good at coming up with processes and procedures. When Congress makes a sentencing law retroactive, for example, and we have to go back and this was really a big deal in the Middle District of North Carolina, where most of our cases are drug cases, and every time they go back and make something retroactive, we have to go back and re-sentence those people. And, we have figured out how to manage that and how to do it. And we do a lot of, if you really want to come, do you really want to come back and have a hearing on this? And do I really have to give you a hearing? Can I not do it on the paper? All that kind of stuff. So that terrifies me.
I just want to step to a higher level in terms of all these cases together. What do they mean? The first thing that they obviously mean is that at least 5 members, and I'm leaving Barrett on the bubble. At least 5 members of the court are extremely hostile to our government, to big government. So you might want to ask, well, I'll just cite something that Gorsuch has said in various concurrences and then come back to a question. Gorsuch says regulation should be really hard, probably passing laws should be hard, because they restrict the liberty of the people who are subject to those laws. Well, the question I want to ask, and you use air pollution as an example, is whose liberty interests are at stake? Yeah, obviously it restricts the liberty of polluters, but why did Congress pass the Clean Air Act? Because air pollution, which damages health or kills people, is restricting their liberty. And Congress didn't ban air pollution, but it didn't but it ended in 1970, it ended the previous period of basically free license for air pollution, and it tries to balance the interests of the regulated and the beneficiaries of regulation. Gorsuch doesn't seem to have the beneficiaries of regulation in his view. Thomas and Alito and sometimes Kavanaugh are of the same, displaying the same tendencies. So why do we have these laws? Because there are, in this complex, especially in this complex industrial world we live in, activity by one set of people harms other sets of people, whether it's pollution or unsafe drugs or economic fraud. And that's why we have these regulatory agencies. And in order for them to, and the other reason we have it is there's so many questions of this kind, and they're so fine-grained and so much to be developed in the future that Congress cannot write laws of exacting specificity, and they can't, it's like agencies, like judges can't do the workload of administrative law judges. Well, Congress can't do the workload of administrative agencies. So if you are bent on basically rolling back, I would say destroying the federal government's, if you're trying to use one tax advocate's expression, you want to get the government small enough that you can drown it in a bathtub. This is the theme of some of these decisions. Why do I put Barrett in a different place? Because she's kind of struggling in her major question concurrence that you referred to in, I think it's in the case about student loan.
Right.
And
Biden versus Nebraska, for those keeping score at home, yes.
And the Chief Judge Chief Justice in Loper Bright, where he says what I referred to earlier, that when Congress passes a law that gives agencies discretion, that's the law. And in the West Virginia case, he wrote that much, even though he recognized the major question doctrine, that is a much narrower opinion than Gorsuch would have written, or Kavanaugh, who came up with the idea, would have written. So, we have to see how far they take this and how much it hamstrings the ability of us as a people to have a government that is capable of dealing with modern scale problems at the speed and gravity that they come at us.
Well, it's going to be interesting to see too if they don't seem to have the same objections to state regulation. The states have much broader powers, police powers, and so there's some things with a lot of overlap with the FDA, health and safety. You're going to have preemption questions that come up, and pardon me, and if the federal government can't do it, are they going to let 50 states do it differently? And I don't know.
Well,
not tomorrow.
There's a significant question which might come up, which the Supreme Court is considering a petition on that. There's a raft of lawsuits brought mostly by local governments, but also by some states, under tort theories or fraud theories and so on, against oil and gas companies and some other large greenhouse gas polluters on the theory that you misled us you knew about this stuff for 50 or 60 years. You knew about the risk. It's well documented.
Opioid litigation like that,
It's
too.
similar. But the oil and gas companies are asking the Supreme Court to stop this because it's inherently an international and federal scale issue. States and localities and state tort law should be preempted. In a case in 2011 called American Electric Power versus Connecticut, the Supreme Court ruled that the Clean Air Act displaced federal common law of interstate air pollution. And they said basically the regulation of power plant emissions, which does go interstate, is under the jurisdiction of EPA under these provisions I've just been talking about. And so the enclave of federal common law reserved for interstate injuries that Congress has not addressed statutorily, that enclave doesn't exist for pollution once the Clean Air Act was passed. Okay, but they reaffirmed that this was EPA's job under the Clean Air Act. Now they're being asked to say that state tort law and state fraud law, state consumer protection law is preempted with respect to greenhouse gas pollution because this is somehow inherently national or international.
So I want to get a question. I'm going to ask you one quick question, and then I want to get to audience questions. Is there any of these cases that you look forward to dealing with? Are there any of these cases that you look at and you think, okay, this actually might, I can see the benefits and
I think the major questions doctrine is we've had a government, a Congress that's been broken for a couple decades now, right? You know, and you see presidents trying to deal with this by executive order or things like Biden did with student loans, you know, trying to take some statute and push something into it that doesn't fit. I think maybe this forces us as a society and a culture to confront the fact that we've let Congress get broken. And now maybe instead of trying to do creative things by the president, we can go back to acknowledging that we have to compromise in Congress if we're going to have any laws, if we're not just going to grind to a halt. And so I think that major questions cases of saying, whoa, stop. Like there's no way that when Congress passed this law 30 years ago that they intended this thing to happen, that will force, you know, Congress to then take it up. Like if Congress wants to do something about student loans, they're now going to have to deal with it. So I think that's a positive.
I just don't know if it'll work. I mean, it's true the Congress is broken, but even what I think of as the great Congresses of the late 60s and 70s, which were passing all these civil rights laws and environmental laws and so on, and we're bipartisan and we're truly, they were led by truly capable senators and congressmen and staff. They had the capacity and the willingness to write big laws, but even those couldn't project into the future far enough, so they had to delegate. We don't have I mean, I think the goal of some of the advocates of these positions is to, you know, electric cattle prod the Congress back into legislating again. But the goal of others is just to say, fine, we won't have a government anymore. It's fine with me. We want to drown it in a bathtub.
Judge Eagles, is there any of these that makes your life in any way better?
No.
All right, a good All right, let me throw it over there.
No, they don't make it worse, but they don't make it better.
But it sounds like the uncertainty may make it worse, right?
Well, but I mean, that's my bread and butter. If there's no uncertainty and no crime, I don't have anything to do. I mean, so that is why I am there, is to resolve uncertainty. So if I don't have uncertainty over Loper Bright, I got factual disputes to resolve and jury cases to try. And I mean, uncertainty that's just what I do every day.
All right, so just to be clear, so the implication is you should go commit crimes. I just want to be clear about that, at least in Durham or Greensboro. All right.
No, please don't. No guns, no drugs.
I saw John Peckin.
Perfect. Judge Eagles, you had mentioned delegation as a potential watchword for the future. And I guess I would appreciate if y'all could speculate a little bit, read the tea leaves a little bit more. Certainly when some of us were looking forward to some focus on the major questions doctrine, not normatively, but descriptively, post King versus Burwell, before West Virginia versus EPA, looked like maybe there was delegation lurking somewhere in major questions. That was not the case. Is delegation going to come up more precisely?
It's so statute specific, right? I mean, everything's gonna have to be decided, this is how we always do it, case by case, statute by statute, subsection by subsection, and beyond that, I know nothing.
You want to go?
I was just going to say, I think the non-delegation doctrine we're going to see something there, and it's going to be interesting, right? And I think it will be a pullback to no, actually, Congress does have a job to do.
Well, I mean, the major question doctrine, Loper Bright, so on, they are premised on that delegation is legit, that there is legitimate delegation. I'm trying to think about how that passage we were referring to and that you quoted from Loper Bright might have been written. And maybe it was written in the draft as without the phrase within constitutional limits, but by the chief. I don't know that, I'm just speculating. But then if he hadn't included those words, either anticipating it or on his own accord, they would have been thrust in there by Thomas and Alito Thomas and Alito would like to just wipe out large parts of the government and the authority, and you could do that through reviving the non-delegation doctrine. I think the way these things have been written so far by the chief is more careful, and that he realizes, first of all, he's a step-by-step guy, but he realizes the convulsive implications of going with constitutional rulings that Congress couldn't change. So I don't know what to expect, but I think of them as, there's Alito, Thomas, and then, you can predict. The three liberals you can predict. And then there's Barrett and Kavanaugh and the chief. Who am I leaving out? Gorsuch. Even Gorsuch. Gorsuch is in that, in the theoretical level, he's in there with Alito and Thomas, but he's a little more practical than they are. So, I thought the Ohio case, which is not about delegation, was really interesting because Barrett basically said, enough. Enough of using the shadow docket and enough of getting into the nitty gritty of this. The EPA did a damn good job on this and we should keep our noses out of this. I wasn't surprised that the liberals would think so, but it was a surprise and welcome that she did. So I don't know where the court's going to go on this, how radical. I think we all got to watch it. And there are, the whole Federalist Society apparatus is trying to set up these cases and to set them up with, small business herring fishermen, red herring fishers as the plaintiffs.
Other questions? Yes.
Hi, thank you so much for coming. I think I was wondering when you were all talking about the level of uncertainty that these decisions bring, whether or not kind of the focus on returning power back to Congress would be maybe a way that could possibly lead to more certainty in a sense, because I think you still have the uncertainty of changes in administrations that the agencies have to deal with, which could upend a whole set of rules and regulations every 4 years, right? So I'm wondering whether or not you think that's, also a problem, or at least as equal of a problem, that the court might have also been thinking about, and maybe it wasn't just trying to upend everything or something like that. It was just returning maybe to something that would actually be slightly more stable if we did take the impetus to kind of bring things back into Congress. I
want to be a panelist for a minute, because I'm glad you mentioned this, because it's something I probably should have mentioned. One of the critiques of Chevron is it allows agencies to switch policies every 4 years. Because the whole point is, if the statute isn't clear, then we'll defer to any reasonable interpretation. And by the way, that happened. It happened that the FCC enacts net neutrality rules, and the court says that's permissible, and then the FCC revokes those rules, and the court says that's permissible under Chevron because the statute is ambiguous, and so we can ping pong back and forth. And so a different kind of uncertainty that Loper Bright changes is No, once the court has made an interpretation of the statute, that's what the statute means, and you agency then don't get to keep on changing with each presidential administration. So this is not going to be, might not be helpful to anybody on this panel, it might be helpful for you. So in 20 years, after all of these various statutes have been interpreted,
It's still going to be practical.
then we might have a lot of certainty and knowledge, because all these statutes have been interpreted, and we'll know, and it won't keep on changing with each administration. And that is one of the critiques of Chevron. I just want to be really clear about that, is you are giving too much room to the agencies and the president to make these determinations. Now, last point on this is, and others would say, that's not a bug, it's a feature. We want that. We want elections to matter. We want elections to have, so you can have a different normative take on that, but it is true that Chevron allows for this flip-flopping in a way that Loper-Bright may not.
I would just say, at least in my area, there are a couple of areas where there have been flip-flops on controlling power plant carbon pollution, for example. But the vast majority of the regulations are stable, and you don't have that kind of flip-flopping. So I think it's sort of a cause célèbre rather than a deeply problematic flip-floppy thing. But I would like to point out the reason we haven't had, I'm the author of the little-known Doniger's Law. It's the opposite of Moore's Law, that computer speed doubles every 18 months. My law is it takes twice as long to amend the Clean Air Act every time around. It's 3 years, 7 years, 13 years, and now it's past the 26-year mark that I predicted. But it's because Congress is closely divided. The Senate has the filibuster rule, which when we're in the majority, we hate because it lets the minority block amendments. And when we're in the minority, we like because it prevents the majority from running roughshod over the statutes. It's very hard for Congress to amend these laws. The Congress has damaged itself, and we have damaged the Congress by making it so partisan and by electing people who have such deep disregard for expertise themselves. But we're about to see whether the Republican Congress can reverse major parts of the Inflation Reduction Act, which was adopted on a 51-vote majority under a procedure called reconciliation, which is budget-related and is an exception to the filibuster. So you can get things done when you have a trifecta on a 51-vote basis in the Senate that you can't get done for matters where the filibuster applies. We're about to see how radical a flip-flop we get from the Congress on this important law. There's already proposals to revoke the $35 a month limit on insulin costs. It's just, there's no end to to what they, my opponents want to change. But I don't have much hope at all that we can amend these statutes because we want to keep the filibuster. Even when Democrats are in charge, most institutionalist Democrats don't want to change the filibuster because they can see the years coming when they won't be in charge, and vice versa. Senate Republicans also want to keep the filibuster. So it makes legislation super hard.
All right, in the negative 30 seconds, if you have any final thoughts, Jennifer or Judge Eagle, then we should wrap it up.
Good, thank you
I'm
so
really
much.
sorry to take
All right.
a lot of time.
I thought, we're going to 145? Oh.
Oh, I thought it was 1:30.
I thought, I'm sorry, I totally misunderstood. I thought it was, all right, great. What? Go.
I just want to pick up on what David just said and said previously. And we're in a room here of faculty, law students, lawyers, and on the live stream, similar attendees, but also non-lawyers. So I'd like you to imagine what I hope is not a likely scenario, but I fear is a very likely scenario. We have a government budget that has been slashed by 33.33%, $2 trillion. We have a dysfunctional Congress. We have a court system overrun with cases that it cannot handle. here we have a representative of industry, a chief judge, and a lawyer from a group that does impact litigation. What can we all do in response to the paralysis, not just uncertainty, but the paralysis that those scenarios coming together may result in?
Vote.
Well, I think,
Gerrymandering. You can work locally on states decide voting districts. And when in North Carolina, where I have some experience with gerrymandering litigation, if your districts are divided so that clearly a Republican is going to win or clearly a Democrat is going to win, then you don't get moderates and you don't get people who are going to compromise. I don't know if that's possible, but the Supreme Court doesn't like gerrymandering lawsuits either, and is fine with the state deciding based on partisanship, pretty much, as long as it's not a cover for race discrimination. So, a lot of it starts there.
so within that context, thinking about areas where we've been able to be successful, even in this relatively polarized and paralyzed environment, there are often situations where industry and the environmental community or other, groups like ours that focus in other areas can find common ground. It may be because we've been able at a state level to get some action, and that creates uncertainty, or that creates some of a patchwork of how things work. And I'll be honest, sometimes we do that on purpose because we're trying to motivate, not only get the benefit that you can get at the state level, but motivate the industry to cooperate. I've had a long history of fighting with the fossil fuel industry, and there's no love lost, and not too much cooperation. Some, but not too much. Another area I worked on is protecting the ozone layer and dealing with the chemicals called CFCs and now HFCs and so on that hurt the industry, and that particular hurt the atmosphere. And that particular industry had a sort of come to the table moment in the 80s after 15 years of behaving, like any other trade association. They said to themselves, we're either going to be on the table, we're either going to be at the table or on the menu. And we have worked out regulatory, legislative, international treaty, common positions and agreements. And we passed the only major environmental law that got passed during the Trump administration, signed by the president, regulated these refrigerants. And it was passed on a bipartisan basis with the support of the industries and the environmental groups. We have to find ways to do that. It's very hard, in my experience, to get the hardcore, oil and gas related, coal related companies and polluters to want to come to the table like that. But when we can do it, we can negotiate stuff and present deals to Congress and move forward with them on a bipartisan basis. The chief sponsor of this HFC bill that I'm talking about was John Kennedy of Louisiana. We did it. I hope we can do more of, even in the next 4 years.
So maybe a less flippant answer to Beth's question too is that, I like to think about, even in the grim circumstance that you just described, I like to think about balance over time in the United States. We swing one way and then we swing back another way. And I've looked at what's been happening in Europe in about the last decade in terms of regulation. Europe is regulating itself out of existence. The work week there, the different regulations that exist just for the sake of giving the European Union something to do. These are not regulations that are actually advancing anything meaningful. And if you look at the European economy and what's happening there, it's easy to see. If you think about COVID vaccines, there's a reason why all the COVID vaccines were developed in the United States. It's the strongest pro-innovation, but also, by the way, the best safety record for vaccines of any country on the planet. And so if people are worried that the United States has shifted in the last 25 or 30 years to this very pro-regulatory state. You know, maybe what's coming now is a little bit of an anti-swing back, and we're going to stay somewhere in the middle at the end of the day is sort of my hope. I don't think that we're frankly going after, no one, regardless of political party, wants brown air again. It's just, you know, and so I think that there are some things that we're going to stick with regardless, but maybe some of the things that people are getting really worked up about right now, some of this ESG type things that don't really advance anything, maybe some of those will go by the wayside.
So I was actually going to push this to you, best question, in a slightly different form. So I imagine from Merck's perspective, let's just imagine there's like a government shutdown or an FDA that's unable to function.
Yeah.
I'm imagining that is not a welcome world for,
No.
So is that basically a disaster for you?
Absolutely. I mean, when we talk about the suite of cases as potentially weakening the regulatory state, I think that most of business would say that isn't a good thing. This idea that we have government that has rigorous regulations and oversees what we do so that we know that, you know, when we buy a product and it's a cell phone, it's going to do certain things for us and it's not going to steal all of our personal privacy information, you know, or, you know, the government stamp of approval that comes from our regulatory state is really important. Like when I travel to Germany, I don't ride the roller coasters at Oktoberfest because they don't have a tour system. You know, I mean, it's like in the United States, our government really is a stamp of approval. And so if you strip the agencies of their power, that is bad for business as well. And it permits a race to the bottom. My company's been around 130 years. We believe in producing quality products. If some upstart can come up and not have two adequate and well-controlled studies and just say, hey, my product cures cancer too, then we're back to like the 1800s with like the wagon rolling through with the patent medicines and like, you know, it's a bad state of affairs, so.
So I should not drink raw milk then.
So that's actually a funny but very good example. FDA has a regulation that one district court judge that I litigated in front of thought was ludicrous for milk. So if you call something milk in the United States, FDA has a regulation that says it has to be pasteurized, it has to be a certain percent of fat, it has to be from a cow, and you know, and if you call something milk and it's not that, it can't be on the market, and it's important. You know, I mean, yeah.
Don't worry, David shall return. Any other? I have another question, but if there's other questions from the audience, I don't want to pretermit any other question from the audience. So, yes.
So I don't know how many of you guys saw the Wall Street Journal op-ed after the election by Elon Musk and Vivek Ramaswamy. They said that the major questions doctrine and the death of Chevron quote, together suggest that a plethora of current federal regulations exceed the authority that Congress has granted under the law. And that DOJ, their new non-department, will work with legal experts embedded in government agencies aided by advanced technology to apply these rulings to federal regulations and present a list of regulations to President Trump, who can, by executive action, have Congress here, immediately pause the enforcement of those regs and initiate the progress for review and rescission. So all of a sudden, Loper, Wright, and West Virginia very much come front and center. If it's going to be a basis for someone to decide in fiat that these legal rulings now mean that the regulations we have in place are themselves already invalid. And I was wondering what you guys thought might be the result of this predicted process. Our new department of shrinking government is
Lawsuits. That's what I think.
good for you.
Well,
Let me say, so Vivek Ramaswamy went to the same law school that I did, where law is not taught, so the problem is pretty straightforward. Is as a president or as an agency, there are a certain set of rules that are on the books, and everybody's obliged to follow those rules unless you actually go through through a rescission process, which is the exact same process as it takes to implement a regulation in the first place. Now, you have some ability to change enforcement, but the Supreme Court has said that if the enforcement gets to the point of simply abdicating, then that is effectively a rescission, and you don't get to do that. So it's not going to be there will immediately be a challenge, and I predict that if they actually say, we are simply not going to enforce this, then under some cases, I won't bore you with, but there's a set of cases that we would now have triggered, okay, then that is effectively a rescission of the statute, and then you have to go through the same process that created it, which, by the way, takes a very long time. So I think this is, to use a technical term, blowing smoke on the part of those two op-ed writers. But having made all these strong claims, others can feel free to.
I won a case of that nature in the first Trump administration, where they said, we're just not going to implement certain HFC regulations. And we sued in the DC circuit, and they said, sorry, you can only do that through rulemaking.
So what happens if we have a reprise of the Cherokee Nation's decision? John Marshall has made his decision, now let him enforce it. And you have an agency that says, well, fine, but I think you're wrong, and we're not going to do it anyway. Where do we go from there?
I have a thought on it, but others.
I would hope criminal contempt. We're talking about the rule of law, I mean, I hope that people take that seriously forever.
Judge Eagles, did you want?
I've held people in contempt. It's pretty challenging. It's got all kinds of procedures. Criminal contempt has to occur in front of you. Civil contempt is what you do outside the courtroom, and you have to have hearings and trials. But yeah, I mean, it's always an option. But if we don't care about the rule of law anymore, I mean, I don't know what we do. That is why businesses are here, is because we have that. And so, or at least I think that's right?
Absolutely.
Okay. And that is why we have our individual liberties. Because if you don't have a rule of law, then does that mean the police can stop you and throw you into jail without probable cause? Does that mean they could search your home without probable cause? I mean, it's got a lot of ramifications.
I mean, I guess ending on, I don't know if it's a cheering note or not a cheering note. I mean, look, there's a set of norms, and we hope that people will follow them. So we hope that a variety of people will in fact say, I understand person in, president or important person in the executive branch that you are saying X. I also understand the Supreme Court has ruled not X, and therefore I'm going to follow the Supreme Court. Whether it sounds strange to you or not, that is actually what happened in the civil rights movement in terms of desegregation of schools. And in fact, one particularly notable example was when the state guard did not want to enforce a desegregation order, and then they were deputized by President Eisenhower, and that having been deputized, they were now subject to his commander-in-chief, and they then did enforce the desegregation of a school that they would not have wanted to do as an organ of the governor, and they probably didn't want to do it in their heart of hearts either. But they did it because they understood the role that they were in now that they were deputized by the president. They were simply in a different position. All right, now having misunderstood the end, we now are at the end of our time. So everybody could join me in thanking the panelists.
Nice to meet you. It's nice to meet you.
Nice to meet you.
Yeah.
Thank you very much.
Thanks.
What was the name of the case that you?